Thank you. We're back for another video, and by popular request, we are going to address Erie, the Erie Doctrine. All right, now here what you want to do is pull up the coggle that I have on the website. Go to my website, find it there, or just do a Google search for Nathenson, coggle, Erie, and you'll find it right away. You ask 4 questions when you're analyzing Erie, and I'll get to those in a sec. But first of all, let me talk about Erie itself. Erie has a lot of moving parts. So, depending on the fact pattern, you may only have to talk about some of them. All right? So make sure you understand all the various branches of the Erie analysis to figure out which branch or branches you need to go down. At its most basic form, Erie is about a conflict between state law and federal law. Which one do you use, right? So, you're going to be in a scenario where there's some sort of state law and some sort of federal law, and there's that conflict of those 2 laws. How do you resolve them? And you ask, now we go to the coggle with 4 questions. You're in a diversity case, which law do you use? You ask 4 questions. Step 1, determine the content of the state law. Step 2, determine the content of the federal law. Step 3, determine the type of federal law that's conflicting with state law. And then finally, way over here, then analyze the conflict. Let's talk about these 4 steps one by one. Step 1, determine the content of the state law. That's the question of horizontal conflict. All right? If the choice between federal law and state law is a vertical conflict between the 2 court systems, federal and state, then this first step requires us to consider the horizontal law, which state's law, right? So P sues D in federal court diversity in the state of Florida. Well, you would think we use Florida law, but it's not that simple. Depending on the facts, depending on the law, we may use Florida law, California law, Pennsylvania law, even Florida law. So the first step, under step 1, is to apply Claxon. Claxon tells us that when in, and if you want, Ashley, please go ahead and do zoom right in on the language. That it may be more important than what I'm saying in my face. All right. Under Claxon, what you do is use the choice of law principles of the state in which the federal court sits. So if we're sitting in federal court in Florida, then we would use Florida choice of law. All right? Now think about it pragmatically. If I wanted to analyze Claxon, I would probably have to tell you not just what state we're sitting in, but what the choice of law principles are of that state, right? And that might be a signal to you to engage in some Claxon analysis. All right? Once you figure out what the choice of law principles are for that state, then you can figure out which state's substantive law would apply. Now, it might just be a state constitution or statute or other textual law. If that's the case, now you know your law and go to the right-hand side of the coggle. But what if the relevant state's law is common law? Well, then you have to make an Erie prediction, right? Erie prediction means that you apply the state common law as it's articulated by the highest court of that state, unless you predict that that highest court of the state would now hold differently, right? So use the common law enunciated by the highest court of that state. It's not spoken on the issue, make a prediction. When the state Supreme Court has spoken on the issue and say that the state law is stale, then predict how that state Supreme Court would rule today. Of course, in the real world, a federal court can certify an issue to a state Supreme Court to try to get an answer, but you're not going to have that opportunity on the exam, so you need to make the best prediction. Now you determine what the relevant state law is. You go to the right-hand side of the coggle, because we've already done this. We've determined the content of the state law. Now we've got to determine the content of the federal law, right? And again, that might be the U.S. Constitution, it might be a statute, it might be a federal rule, it might be a judge law or something else. Well, the first question to always ask yourself is, can the federal law and the state law coexist? Can both be applied at once? And that problem number 1 of the problem set is like that, right? P PSUs D under a state cybersquatting statute and under a federal cybersquatting statute as well. There's no reason why these two laws can't coexist, and you could use both. But what if they do conflict? Then you need to continue the analysis. Now it becomes crucial to determine not what the federal law is, but to determine the type of federal law that it is that's conflicting with state law. This is one of the harder parts of the analysis. It's often debatable. The court's not always been consistent on whether to use, for example, HANA 1 or HANA 2. And in fact, you have quite a debate raging in the court in the Shady Grove case as to whether the conflict between federal law and the New York State law was a HANA 1 analysis or a HANA 2 analysis. Well, here's a guiding principle. Here's some guidance supplied by the Supreme Court. If the FRCP rule is ambiguous, then treat it as meaning what it says it means, all right? But if FRCP rule is ambiguous, then Shady Grove tells us, say Shady Grove, that would be like a, like a club from the 1960s, yeah. If FRCP rule is ambiguous, then see if you can read it to avoid causing a problem under the RDA, or that might lead to substantial variations in outcomes, right? That's what note 7 of Shady Grove, we can look back at that. Ultimately, however, if you're in doubt, analyzing the alternative, that means you may have to consider the outcome of the alternative. Step 4 now is to analyze the conflict. And depending on what sort of law you have, and depending on what sort of analysis you made under step 3, you may have to engage in multiple analyses. So I think an example of how you've done this before is when you did the stream of commerce analysis in the fall exam, and you had to analyze under the Brennan approach, the Potter approach, and the Stevens approach. Well, the easy one is when the federal law that's at issue is the U.S. Constitution versus state law. There really is no analysis to do here. If it's a direct conflict between the Constitution and state law, the Constitution wins. Why? Because of the supremacy clause. Use federal law. Also, a fairly easy example would be if there's a square conflict between federal procedural law, such as the venue transfer statute, and state law. Consider this to be kind of an abbreviated way of doing HANA Part 1 analysis. All right? All you have to ask is whether or not the federal statute is a valid exercise of Congress's power under the Constitution. Okay? And indeed, Article 3 and Necessary and Proper Clause do give Congress the power to create procedural statutes. All right? If the federal statute is valid, use federal law. If it's invalid, use the state law. And in doing this analysis, all you have to do is the arguably procedural, ergo constitutional part of HANA Part 1. Remember, HANA Part 1 is actually about FRCP versus state law, right? What if it's a statute versus state law? Well, I just said, a statute is constitutional so long as it satisfies the Constitution, right? It was a valid exercise of Congress's power. Well, if a congressional statute on procedure is arguably procedural, that's the end of the analysis. If the statute is arguably procedural, then it's constitutional, was within Congress's power. And if the federal statute is conflicting with a state law, it's a direct conflict, that's the end of your analysis. You use the federal statute. All right? The harder cases are when the conflict involves either an REA rule such as FRCP or judge-made procedures such as in HANA Part 2. HANA Part 1, right? All right. If you have REA rule conflicting with state law, all right, that's Rules de Legate analysis, also known as HANA Part 2 analysis. I think a few minutes ago everyone used to call it HANA Part 1. Okay, REA is HANA Part 2. All right, so REA, HANA Part 2. The first thing you have to ask about the rule is it constitutional? And we already talked about that, right? A rule, just like a statute, is constitutional if it's arguably procedural. All right? If the answer to that question is yes, Constitution, then you continue. analysis continues. If the REA rule is constitutional, you also have to ask if the rule is valid under the enabling statute, the Rules Enabling Act. And here we have, unfortunately, a split in the authority. To analyze the statute, Scalia would simply ask, does the rule really regulate procedure? If the answer to that is yes, then the rule is valid and you must use the rule and not state law. Use federal law, here the FRCP rule. The Stevens test wants you to look at 2072A and 2072B, all right? He wants you to do this part of the analysis, really regulate procedure is 2072A, and he wants a separate analysis of 2072B, does the rule abridge, modify, or enlarge any substantive right? If you get both of these, and federal rule is still valid, then you use federal law. So you can see with the REA analysis, there's a lot of steps. And one of the things that make REA scenarios difficult, say you have a federal rule that's arguably an issue, well, the question of whether you do REA analysis, HANA Part 2, or you instead use the modified outcome determination test, HANA Part 1, may depend on how broadly or narrowly you read the federal rule. Keep in mind that in Shady Grove, okay, Scalia and Stevens read FRCP to cover the situation, right? Rule 23 covered the situation, therefore they both analyzed the conflict under the REA. Justice Ginsburg in dissent said, no, Rule 23 doesn't cover the situation. Instead, this is judge-made procedural law versus state law, in which case you use HANA Part 1, which is the modified outcome determination test, twin aims analysis. Well, what a mess that is, right? Think of all the steps you have to analyze if an REA rule is an issue. All the stuff, I wish I had a laser pointer here, all the stuff the REA rule branch you have to do, and you'd have to do everything in the judge-made procedure part of the analysis too. It's a lot of analysis to do. So read your facts carefully. If the facts arguably involve a rule of the FRCP, then chances are you may have to engage in analysis of this part, judge-made procedure, as well as HANA Part 1, the REA rule of the analysis. On the other hand, if the facts don't involve a statute or a rule of the FRCP at all, then you do not have to engage in REA analysis. Okay? So say, for example, we had a case kind of like a York, right? On the one hand, you had a judge-made preference for using latches and equity, as opposed to a state statute of limitations. Did that case involve a rule of the FRCP? At all? No. All right? That, you would now analyze facts like that today under HANA Part 1, Modified Outcome Determination Analysis. So read the facts carefully. They will be your guide in which parts of the analysis you have to go down. Don't go down a part of the analysis that is clear issue spot. Okay? Only go down one of these paths if it's arguably an issue. And in the hypo I just gave you, REA analysis is simply not an issue. So, say you do have judge-made procedure conflicts with state law. Well, that's known by a lot of names. HANA 1, Policy Erie, a guided Erie, Rule of Decision Act Analysis. It's also known as Prophylactic Erie. It's got a lot of names. All right, here's my approach, which I take from Freer and Glannon. First step is to do outcome determination. Would using federal law substantially affect the outcome? If so, move on to the next step. Would federal law lead to inequitable outcomes or forum shopping? All right, forum shopping refers kind of like what would a plaintiff do? Would a plaintiff choose to file in federal or state court depending on which law was used? If so, that may have a forum shopping problem. Inequitable outcomes seems to be more of a normative judgment by the court that it would be simply unfair to allow federal law to be used as opposed to state law. All right? Well, say you get past the outcome determination test, right? So say you do the outcome determination test and it tilts towards using not federal law but state law, all right? Well, that's not the end of the analysis, because then you want to talk about about Byrd. And Byrd, terrible opinion, Justice Brennan says sometimes even when outcome determination leads to the use of state law, sometimes there's countervailing considerations that say don't use state law, use federal law. All right? And very unhelpfully, Brennan said the existence of the federal court system as an independent system for the administration of justice was a countervailing consideration that says don't use state law, use federal law. But let's think about this. In what percentage of cases filed in federal court are we using the federal system for the administration of justice? What's that? All of them, right? So take Brennan for what you will. Come up with whatever arguments you can if you get to that stage of your analysis. What Brennan actually means is not very helpful. All right. The last part to consider about Erie is constitutional Erie. What started it all? When you have state substantive law, such as the duty owed to trespasser, versus judge-made substantive law, a common law substitute, come up with judge. The judge is like, I don't care about that state common law. Those state judges, they don't know what they're doing. I can do better because I'm a federal judge. Tenure for life without that diminution in pay. And here's my own federal law that I'm going to make up because I'm awesome. All right? Well, that's federal general common law. Can't do it. It's unconstitutional. It doesn't exist. In fact, there's no conflict at all because the judge lacks the power to create it. All right? Federal general common law doesn't exist. You use the state law. You don't care about outcomes. You don't care about forum shopping. You don't care about inequitable outcomes. You don't care about countervailing considerations. If this federal law that might conflict with state law is federal general common law, you know, a federal judge-made common law is a substitute for governing state law, you can't do that. You just use the state law. And that, of course, takes us full circle back to constitutional Erie, which is Erie versus Tompkins River. And that's the Erie Doctrine in 10,000 words or less. Thank you.